500 billion into court and say no dear ridiculous, and that was him or ban contribution be and whatever can ware no in that period of time a bit me generate high interest no. And so based on that, court and say obano obema no 300,000 pay, which is 3 billion old currency into offer 3 billion enka niema wenya ho. So obana said that the 50 million Ghana cedis in a dear chenchene twan obana say we deserve it. And into na offer lawyers in the person of Godfred Dame, the former attorney general, omo ekoye appeal nebusia omo etimi akwaje se sika no se chinchine twa se sika no bagina 3 billion a day manaka ne cars ni fie no ho de ompe abuzencha o mepacho. There is a dramatic divorce ruling at a court etimi ama ene I won say many na mfra me maybe a watete no hu mepacho full details metimi ama breakdown ni na Richard ni amakui RNAQ, what is the Bugatti man aka Didinako free Richard Niama Kwe, a former wife and as an ex-wife currently because court telling me I'm a divorce and granted. Neya your friend say Joanna Kwe, Miss Joanna Kwe, it me at the Richard Niama Kwe could mu e court say or then for 16 years or more a warrior. Krami and Sabemu, a Japadiaba, what as they say, you can use a Bugatti near the identity court and say. Na ono so intimi enje oba ne chefa oba ware no ultimi eye emfama. Now for records, this woman awade Richard court no, she is also the co-founder, the director and shareholder of Bills Microfinance Richard Niama no ono so ka ho bi ento ultimi go pie court the reliefs near the ade ekoto court enim se court intimi nyina so na aware na gundie o intimi enye ne chefa na eja onko ne baby. Now interestingly, court need to me here in 7 na ruling na aba na busia sika bia na ewo mu a oba na se ohwehwe which is 50 million Ghana cedis enka be ma no court enyin free be ma no mo oba no asempata for ne chefa oba ware wotimi enya 50 million which is ene and I say the old currency no 500 billion eni sika no ohwehwe aside that 500 billion na or sign so per cars ni efie bi ni ade afie custody of the children and all that. But interestingly, Sikana na Washington, which is the 50 million Ghana cedis, 500 billion. Mebato court no emanimu 0.6% per and a court nitime grant mano, which is less than just when 5 billion pu. And no air the court ne grant mano. Never calculate to who sika court na award mano. Any other reliefs are not a womb. Now, based on that ruling, no, on the 50 billion woman no because other things with me when a cast ni if you be near that with me, I bet. 500 billion na wohwehwe na court no entimi angrante amantino obana science wa file petition and also wa file appeal. Now the appeal lawyer this time will lead the former attorney general friend Godfred Dame wono na Richard Niama Kwe ne ex-wife wetimi akofa say ondi nanim na omu appeal the 500 billion the 50 million cedi alimony and also sika mpatesika awoje aka eniema wenyenya no no wetimi akopi appeal was court intimi ehwem na omu intimi enje se sika no manti ende chenchena achen obeje na oba no kopie court no enema initially nanka ohwehwe ni bi enie okose court intimi finalize divorce no a divorce decree in favor of the petitioner which is court in dissolve aware no na ochimsa aware no mo on the 4th of December 2010 and then oman who said the enema ekono intimi nkoyi it is beyond reconciliation into court intimi nhwe na omu intimi engu aware no ema no. And then open custody of Nema 3 omu ewo mawari no munyaye no enkra 3 enebemu. Now mind you enkra 3 according to sources you say currently they are all below the age of 18 into obano custody full custody of them nanka wetimi ene enkra natana 3 kids ana ewum Rufina Kwe, Brian Kwe and afi no Brianna Kwe. So your Brian ene your Brianna Kwe enkra miensa ewum no a chese obana ese court nso intimi award custody emfama no eno no. Aside that ose pay payment of school fees and then other education expenses for the said children inti enkra na obeje custody court intimi nje custody man no court nsanso nhye be ma no na ontua enkra ni fees and then payment of maintenance and afi nso no eniema ekeke kan ho court intimi enjejeje enka no ho. Aside that, or pay a lump sum of 50 million Ghana cedis, yentimi enje enkan which is the 500 billion. Now, this is the issue currently. What science wako pimu appeal court ultimi yako pili sesika because instead of 50 million, court no eman 0.6% of the money, which is less than 5 billion. In fact, less than 1% of 50 million, which is 500 billion old currency. No. So instead of the 500 billion, court no really no ebetimi amano 300,000, 3 billion per instead of 500 billion. Court need me award 300,000, which is 3 billion. The man was 3 billion one pay into assign so akupi mo appeals court. Aside that, which him say man order following properties be na a woman so no a court intimi NJJ enkan ho inti properties ana ewo or the call currently senka court intimi njema no ifie bi o chem say ewo dansoman with house number 8 Jaffa Lane GA something ewo afin so ifie ba ko ewo East Legon Accra inti fie 2 na nanka ope and also no court no ruling no be nso nya na wanya ni nyina ni yetimi ebem point by point, and then also cast be na involved. Now mind you say if you 2 we no kra no at the later part of the court proceedings, court documents ewa ha ye komu no if you be sign so be kan ho a and the court ni chim say da bi initially the order by say wo hwehwe ni nti say later wo sign so the fee bi be pie so say wo say pe no aka ho wa bra we initial petition na eni mu aye ntimi mfa nka ho enti e bi okwa appeal betimi di nyina so etimi aka ho e wa appeal so, but then if you 2 na involved currently, and then Jaguar Prestige XF 2018 model with registration number GN 2272-18 and also engine can plus the few 2 and you don't know any kind of or and then a Range Rover Velar with registration number M2020 and a face legal cost and other things are caught no ebedi me fit say obetimi ediamano. So we add obano edi kan course or then Richard Niama Queen so yetimi present man say o yere o former wife and say o ex-wife etimi abako say mawari egune niama or hwehwe and then also etimi respond here now in Richard Niama Queen response and we also share and say marriage in the years wajitum yen dissolve into court no ejitum so me no reach that agreement omu etimi dissolve aware no, and that the properties na what down so many easily go no ba no ese or hwehwe no Richard Niama Queen say ono nso pe afin so no Richard Niama say or per custody of 3 children na a woman. So custody na oba na so per oba person nkra na ba no ho. Richard enso say ono so person nkra no e ba no ho. So Richard Niama say nko so per nkra no and that ono abetua nkra ni fees. And afin so no manti bia no a maintenance of 2,000 cedis. So ono na respondent, ono na responded to the case nti no or per custody of nkra no as well as omu fees payment ni ono ankasa betua. What I say. But then in the case of oba no ono pay custody, but then Richard Niama intia for the fees and all that are ewo ho, which means nka petition any mum intia medical and food expenses for the children. Richard no pay custody of the kids, or no as respondent will pay the school fees of the children as well as 2,000 cedis as maintenance fee. But then eba food any expenses there nka the petitioner, which is oba no ne ex-wife no mum nka intia for nkra no. And then also cost biana ebebe nso no court entimi awode Emma Richard so the oba nde koyi ni the Richard nso ehwehwe ni enti na court na etena ase na o hwe niema ni nyina mu hwe ese oki based on the obi ehwehwe the oba nde aba ne ade no nti no ono nso baba rule na court really ni chim say at the close of evidence and trial this court on the 11th day of March 2025 decreed that dissolution of the marriage enti our end the court ejitum say wetwam wetwaware because and omu enu anya atiase but eniema aka we si mepe ne ho na court ni be yusu mra etimi decide say hwan na e deserve. Now first issue na ewum after say ye dissolve aware eniema 3 biem na aba cars which is movable properties and afenso no efi the friend immovable properties and enkra na ewum na court ni timi kire say because enkra no minors and that omuda so wo maame ho as at the time a case na ekoso which is the petition and identity no court ni consider the interest of enkra and then obema reasonable access to the respondent in the court no the enkra no custody be she maame nsa so maame ne we custody of the 3 children but then Richard Niama ebenya reasonable access to the enkra into obetimi akọ visit enkra no on weekends and then also on vacations until or say the children shall spend the first half of every vacation with the respondent which is Richard Niama and then the other half with the petitioner omo maame na wetimi prepare omo edu omo ko school so maame no awe ni enkra no ewo ho so now bema no entua the school fees, educational expenses as well as health needs of the children until after say oba ne we ni enkra no custody no court ahye say Richard Niamakui into enkwani fees omodidi expenses any health needs bia kabi ebeba for omo health bia no wontimi into emomo. And then also when Richard Niamakui yes enko be ope to maintenance of 2000 cedis month bia de amount kran court ni etimi share say enkra no miensa nyina no bosumi bia be ma no emomo 5000 cedis a month for maintenance. Now court ni share say maintenance fee no kra no is subject to review either upwards or downwards depending on stages of life and grad go through as they grow up, they want to leave home and all that, you know. And they be decided say be a I feel the court be say 5,000 a month into be manasa yente so anasa yentum depending on certain things. Enti eno on enkrade into obano arene enkran ka study warene 5,000 cedis a month. I say be man tuama obano no de hwe enkran no for maintenance. School fees be man ne betua hospital bill be man ne betua health insurance and as a health base be ebeba no eno so be man no ene betua enti ewie nkra no ne ebeba properties which in this case ifie any cars eno any the two issues contention wa hasisi ansa na sikasem no which is the last stage eho ena issue wa ama ensemu ekọ viral. Now on the issue of ifie no court na say ifie ne wodan so man no marital property of both parties what I say. And so a no court no etimi chiemu miensa ena ode baako ema obano. The 1/3 allocation should be 3 bedrooms in the building with access to the use of the common facilities. In the court ni chiefie no miensa and ode 1/3 of it ema obano. But then if you no kuma kitchen ni other supplementary rooms e wo ho a enye bedrooms no still obano so e wo access. But then 2/3 of it eno the majority eno Richard Niamakui wono ene benya tumi anase control ewo eno so if you na down so man court chemu 3 bedrooms free mu de ma oba ne se ono mfa because enkra no so ka no ho. And then also the East Legon property and also the house number 72 block 2 section 075 our drink and on also say court ne say on that East Legon property no enye joint property eye marital property inti eno nenye awarefo ni na ye from aware nu. And that is why a court need to make sure say during the court proceedings no oba na intimi am provide enough evidence, enough information on the property echesa ampa na oka ho bi e na say East Legon dan no munyaye enti sa East Legon fie de omu intimi nchem because court chem so oba na intimi am enough proof echese say fie na joint property a omu mienu e na during aware no omu etimi nyaye so e hon de court etimi Edema Richard. There is a first house down so man when you 3 bedrooms. There is the East Legon house and the court in marital property is not jointly owned. Now there are 2 other houses via aside the Dansoman and the East Legon house no. And also wasem ebe mu ananko oba ne se no so opebi. Eno eyifi bia yese baako e o Mamprobi. There is another one e o Trasako Estate phase 2. Now eno mu no court ni chimu say during the time an oba na filing the release and during the proceedings no oba na ntimi an consider say fie no before say almost starting proceedings. So it tells the court ni judge ni chimu say it tells the court say either said then time an oba no file for a divorce any release no one consider say a jointly owned marital property and I said those properties no either say they were acquired during the proceedings after say proceedings no were initiated enti way before say enye say wo munyaa ansa na awade di begu either say oba no consider say saade no say na wo mpa o consider say na oni sutumi na onka ho bia nti no antimi anka ya mfa mehim ana say ebi e kire na sa property na ba wa na court proceedings na cause nti in that case court ni ntimi ngi ntum say a jointly owned marital property as otimi e de eno be ka ho no ntimi e hye. I hold the view that they are not marital properties which cannot be subject to distribution. I accordingly decline making any orders on these properties. It is a fear too, no. The Mamprobi and the Trasako phase 2 na actually during the course of the proceedings or band once and bind the court ne say and also untimi mayenche. So and the Richard Niamakui emfa. So on properties no obane nyamu 3 bedrooms bi ewo down so my dem East Legon de no de or say there be evidence in who say a jointly owned property. And then other two be a beam so court and see because Oban initially went me and found count say or due to me say I didn't know one can hold that. And I say some properties in a buy during after Senate proceedings in a course which in Tianos no me any bearman in Chimti and the bema no emfa ni nyina. And then they came to the cars. Cars no issues be ewa ha. The immovable properties, cars 2, Jaguar Prestige XF 2018 model with registration number GN2272-19. And I think so a Range Rover Velar SUV with registration number M2020. And you 2 cars are initially buy, and then almost had the 2 more cars by and also Obanesa cars in the 4. So the respondent added 2 more vehicles, Mercedes-Benz ML350 with registration number 1725 and Jaguar XF with registration number FF 1825-14. There is insufficient evidence that the Range Rover Velar was meant to be a marital property. In fact, the petitioner could not disprove the respondent's assertion that the said Range Rover Velar belongs to a different person, whether a concubine or any other relation. What this means is that the parties are left with Mercedes-Benz ML350 and then Jaguar XF 2018 model. Now, the ATN say cars 2 initially in a BEM, and then another cars 2 being so on same by. Now, about cars in one, there were cars being involved a Range Rover Velar. Now, sir, Range Rover Velar no, Richard Niamaku, according to court documents in the chamber, said, "Eno die, e will be the enyane dia. Enti anu ye ntimi mfa meka enema e wa ware mu ese yeche." And then court ni chim say, "Oba ne nso ne lawyers e ntimi ama enough proof say ibi aka no oboa enye obi dia, na emom e aware no mu nya enti emfa nka ho. Enti o ma ntimi en disprove Richard Niamaku asmo kan say car ni obi dia. Enti ende o me enche enti ampa court ni yisa aka ni film." But then other 2 cars be womb, which is Mercedes-Benz ML350 and a Jaguar XF 2018 model there. A court no 8 meji to say e omu nyina dia, but no ya de sa cars no ema oba no. E ho na court ni be kire say the financial settlement of 50 million Ghana cedis na oba no e hwehwe no. And also court ni be man ruling, which is 500 billion old currency. Court ni say, "My position has always been that this constitutional right is based on the old time relief of alimony, which was payable to a divorced woman to enable her settle as an independent woman." Court nature say eba aware egu na yetue sika, especially in this case say oba ne so wo 50 million 500 billion old currency. There should be enough or reasonable grounds to believe say oba no then time na would depend on be man so, and that ye jano na aware no gu ni ama no hwe a ontimi enko start ya brabo bi ansa na ya consider say alimony bi ebetua. And na court ne say this was so because in those days the woman was completely dependent on the Bema, on the husband. And according to say times have changed with the advent of independent working women. I therefore hold the view that there must be compelling reasons for such an award. I have taken into account the ridiculous demand. So court nature say 500 billion sa waregu now so the Bema 500 billion court no ridiculous emano, and that it has no basis. And the petitioner did not provide any foundation for such an award. Oba ne say oje 50 million Ghana cedis. The court ne say oba ne ntimi provide evidence bi say ampa o deserve sa payment no. And according to the court, 50 million Ghana cedis from a divorce ridiculous, and there is no compelling reasons oba no obetimi agina so e de age say sika no. E ho na court ne be say marriage is not an investment, and in any case what investment can yield so much dividend or interest in a period of 10 or 20 years? On the other hand, here is a petitioner who has been settled with 1/3 of the matrimonial home, the educational and health needs of the children placed on the respondent, and her mobility issues are also taken care of. Physically, she is very much attractive and capable of remarrying anytime she felt like. Court ne say, as I say, about 50 billion, 500 billion, a ridiculous court no, and that one provided basis be a chesa ample deserve sika, and that when you be not rely solely on the Bema. In teaching so all kon ye ntua alimony bi amana o ntimi nko start na brabo. Court ne chim say marriage any investment, and that court ne chim say ohwemu kra na e dey investment nko na oba ware no be ya in a period of 10 or 20 years. Ofi say investment no a generate that interest of 500 billion into uja ware no e say wo gise sika na odeko, because court no etimi a say be man abetua enkra no hospital bills, obetua mu school fees, yama 1/3 of matrimonial home, physically o cars semni aden so ya sorti aside that physically court ni chim so oba no physically attractive enough and they obetimi so asa ware biom. So it's not like aware no okum na wujai no ebubu na bra bokojokojo a ebia wonya ahwe no akasa no ye justification say na ye ngina so kran gi sika bia emu odu mpo mfama wo. yama oka yama ofi ya sorting nkra no omo fees and all that ani nyina na nya wo hawo enti die nyina so obiem na wo ho yese court no mora yi be na wo ho yese court ni timi gina so saje 500 billion ma so gisa fa nkodi wo asa be ma ni ntiutu asa na ma wi ni ansa ama 1/3 of ifi any ade any cars enti court na se no de ridiculous and that what hwe mo oba no contribution bi no wo de be kan aware no ho a in that period of time ebetimi generate say interest no. And so based on that, court ne say oba obema no 300,000 pe, which is 3 billion old currency. Enti onfa 3 billion no enka niema a wanya ho na aware ni enguo nkwane baabi. So in this case, oba ne benya 3 billion, obenya cars 2, obenya ifie 3 bedrooms. What I say, which is 1/3 of the dansoman ifie. Easily go the end there and then enkwani fees ni ade nyina no ye betua wasan so we ne custody of enkra no and enema e ka ho nyina court ne sa say obetimi so aware eniya asan so live na brabo plus so say competent and capable enough so no anso ye na adwuma it's not like we dependent on bema no we obi a wono obo no homode ye no so ambrabo ni business sinti no the court ni feel say niema ye de amani enough say is it me bo na brabo into one giwe na onko based on this obana said that and yes, cars, the 1/3 bedroom and all that in wajejeje. But the 50 million Ghana cedis in a dear, changing it and Obama will deserve it. And it's not offer lawyers. In the case of Godfrey Dame, or in the person of Godfrey Dame, the former Attorney General, what me aku pimu ewo quarter, or more ekwaye appeal, nebusia, or more etimi akwaji se sikano. Se chinchine twa se ska no bagina 3 billion e de manaka ne cars ni fie no ho de ompe so we eye de wo ho on the Richard Niama ene ne ex-wife divorce case abusu a wote ho nsem se de tie eno no enti e ho nsem na abusu etimi e de ama no medin e de si here na offer 7 cars of subscribe to channel se be ya video bi drop ya obenya update comment section so open che wadwen